Hello, everyone. My name is Matt Rich. I'm an attorney with MidPenn Legal Services in the Harrisburg office. I'm here today to talk with you folks about updates related to the COVID-19 crisis as they relate to landlord-tenant issues. I hope that you all have been able to stay safe and healthy during what has been a rather unprecedented last month or so. Here's a slide with my information. As I say, I'm an attorney with MidPenn Legal Services out of the Harrisburg office. I practice almost exclusively in the area of landlord and tenant issues. So there are two or three major facets that we want to touch on here as part of this presentation. The first is to touch on what folks who are private renters can expect from some recent updates. The second thing that we want to talk about is what subsidized tenants can expect from recent updates, and then also want to touch on briefly what folks that are living in long-term stay hotels or motels or rooming house situations can expect during this time. So first, we want to talk about private rental situations. The Pennsylvania Supreme Court issued an order back on March 18th initially, and it's since been amended several times. The current status is that all Pennsylvania courts are closed through at least April 30th. Now, for any of you folks who may have been following along, or even if you haven't, things are constantly changing and moving in different directions. So the information I'm providing is accurate as of right now. There may be changes that occur in the coming days or weeks or so. As of right now, the governor's shelter-in-place order has been extended to May 8th, although there has been some discussion of opening some businesses on May 1st. So there is at least a hope that the current Supreme Court order may be extended beyond April 30th, but at least for right now, we're operating under the assumption that it's going to expire on April 30th and that the courts will open back up on May 1st. We'll try to keep you updated if there are any changes to that. So now, what does this shutdown mean? So there are a few essential functions that still occur at the courthouse or any given courthouse, such as protection from abuse orders, cases, and criminal matters. Essentially, everything else, though, outside of that has been put on hold. Now, when I say put on hold, that's mostly for the purpose of in-person hearings and proceedings. Cases and the court system are still very much alive, are still very much active. There just have been some changes made because obviously folks aren't going in and out of the courthouse as they would have otherwise. This closure also includes closing the courts of common pleas as well as magisterial district judge offices. The county courts of common pleas have the authority under the Pennsylvania Supreme Court order to enact their own orders, which are working in conjunction with, but which may contain terms different from the Supreme Court's order. So the Supreme Court's order is a default, but the order has specifically outlined that each county court has its authority to enact its own orders, which are meant to fall in line with the Supreme Court order, but the counties are given great deference to make changes as they deem appropriate. So one of the important things to note is that while it's good to know what the Supreme Court order says, it's also very important to check with your particular county court's order because there may be some provisions in your particular county that are different from the Supreme Court's order. The best way to do that would be to either Google that, look that up if you're able to on your own, or to try and contact your local legal aid office. Now, the Supreme Court order, for the purposes of what we're discussing, the most important portion of that for our purposes here today in discussing landlord-tenant issues is the Supreme Court order included a moratorium or a freeze on evictions for non-payment of rent during the time of the court closure. So as of now, through the end of April, there is a freeze on evictions for non-payment of rent. Now, that's important to note that it's supposed to be strictly for evictions for non-payment of rent. There is no provision that says that evictions for other purposes, so whether it be illegal activity, unauthorized occupants, or other breaches of the lease, are not included. So there is a possibility that a person could be evicted for an issue outside of non-payment of rent, despite the Supreme Court order and the court closure. Now, that said, my understanding, although I am mostly focused on the mid-state, so I can't speak for every locality, but my understanding is that generally courts, whether it be magisterial district courts or courts of common pleas, are erring on the side of caution, giving the health emergency. And so even if we are encountering situations where there is an eviction on the table for something other than non-payment of rent, those have generally been put on hold, I think, practically speaking, as well, even though they are allowed to carry on. Now, what does the moratorium mean for a renter or a tenant who's facing or might be facing eviction? So if your landlord had already filed a complaint at the magisterial district judge's office, but the hearing had not yet been scheduled before the moratorium went into place, so around mid-March, then the hearing is going to be scheduled, but will be postponed until at least on or after May 1st. And keep in mind that, you know, the whole court system shut down and everything all at once is being, you know, pushed off for weeks and weeks. So there is a likelihood that even if the court does open back up on May 1st, as is currently scheduled, there may be some delays there because they're trying to reschedule essentially a month and a half's worth of cases at that time. So I know that I have some hearings that were scheduled for the middle of April. They've been rescheduled for around the first or second week of May. And I've been given a directive that there may even be another rescheduling beyond that, depending on how things play out over the coming weeks. Now, if your landlord had already filed a complaint in the Court of Common Pleas, and there is a case pending in the Court of Common Pleas, like say an appeal from the magisterial district judge's decision, then the deadline to file a responsive pleading to the complaint or to whatever pleading the landlord filed in the pending Court of Common Pleas action, that deadline is suspended. So anything that would have otherwise been due to be filed between March 19th and, again, as of now, April 30th, all filings are considered timely so long as they're filed on or before May 1st. So keep in mind that the courts are still open for business. So for instance, I've had clients and tenants that I've discussed mailing in payments if there are payments that need to be made in connection with the pending appeal. I've had some clients drafting up some documents and mailing them in. I've been putting together documents with opposing counsel in some cases and mailing them in, and the Prothonotari's office is still accepting those filings. But if you have a case where you were supposed to file something between March 19th and April 30th, and you obviously can't get there in person because of the closure, you don't have the ability or wherewithal to be able to mail in whatever you were supposed to file, you will be able to file that so long as you get in there the day that the court opens. So again, at this point, that day is May 1st. So if you were supposed to file an appeal that was due by March 20th, and you haven't filed it yet, you would still be able to file your appeal so long as you get in there right on May 1st and file it. Now, again, this is always subject to this changing. It's also subject to local courts being able to enact their own orders that might expand that time frame. Now, continuing that discussion about what the moratorium means for tenants and renters who are facing eviction, if the landlord had already filed to evict and obtained a judgment, whether at the MDJ's office or the magisterial district judge's office or in the Court of Common Pleas, then the deadline to appeal that judgment may have been extended. So again, as I just alluded to, if you had a judgment entered against you the week before the moratorium went into effect and you were gearing up to file an appeal, but you couldn't make it in there before the closure, you may very well be able to file that appeal still, even though we're beyond the 10 days or beyond the 30 days that would have otherwise been in play. You will still be able to file that so long as you get in there the day the court opens. So again, at this point, May 1st. If the landlord had already filed to evict and obtained a judgment and there is no way to appeal, so for instance, if the landlord had gotten a judgment against you on March 1st and you didn't file your appeal within the 10-day time frame to stop the eviction, that time frame would have expired before the moratorium and the court closure went into play. So you would not have the protections of the suspension of the filing deadlines. So as of the date that the moratorium went into effect, you still would not be able to appeal that judgment. If that's the case, even if you cannot appeal, and even if the landlord is processing the case or continues to process the case by going and getting an order for possession, and when I say going, I mean mailing in a request for an order for possession to the MDJ's office, and even if the constable comes and serves the order for possession, you cannot be evicted by a constable or on the common pleas level by a sheriff until at least on or after May 1st. So you still will enjoy the protections of the moratorium with regard to the actual physical eviction, even if you're not able to appeal the judgment. The moratorium is a moratorium on cases proceeding and folks meeting in person in judges' offices. It's also a moratorium on people being evicted during that time as well. So even if there's no other option to try to challenge it, you still have until May 1st before you'll have to leave your apartment. Now, if during the moratorium the landlord files a new complaint, then the hearing again will not be scheduled until at least on or after May 1st, and I would imagine it would be much later than that because again, for all of the cases that were already pending, they're all being rescheduled as well. So if a new case comes in, that'll probably move to the back of the line, and that hearing may not occur until maybe mid to late May, perhaps, depending on the particular MDJ office and their schedule. If the landlord files a new complaint in the Court of Common Pleas, then again, keep in mind that deadline to file a response to pleading is suspended, so you will be okay to file whatever you needed to file so long as you do it the day the court opens. So again, say you had filed an appeal and then the landlord just filed a new complaint yesterday, you would be able to get in there to file, even if it's outside of your time frame to file. Otherwise, you will be able to file that timely so long as you file it on or before the day that the court opens, either remotely or in person. Now, this is to touch on then to pivot into what rooming house occupants or folks who are in long-term stay hotels or motels can expect during this time. Now, these situations are difficult to peg, legally speaking, because there's not a lot of legal precedent out there to follow, and also because there are a lot of factors that come into play that need to be evaluated. And so really when we're talking about folks who are in hotels or motels for long-term stays, if we're talking about folks who are living in rooming or boarding houses, we speak generally to try to encapsulate what we think to be the case, but understand that we're painting with just a broad brush here, and we can't guarantee that this is indeed the case, but in the majority of those circumstances, in almost any and every circumstance, it's illegal for a landlord to utilize self-help measures to evict somebody. So what we mean by self-help is, changing locks unilaterally, or we've seen some remove the front door to the apartment, or terminating utility services by cutting off, say, electric or heat or water. So understand that the only appropriate way for a landlord to evict is for the landlord to take legal action through the court system. That would then result in an eviction by a constable if it's at the end of a magisterial district judge eviction process, or an eviction by a sheriff at the end of a Court of Common Pleas eviction or ejectment process. Now, again, understand though, you have to evaluate these situations and the circumstances in play to first determine whether or not we actually have a landlord-tenant relationship. I am obviously biased because I represent tenants. In the vast majority of these situations, I would consider the most of these tenancies or most of these living situations to be considered tenancies as opposed to trespass situations, which is the alternative. Like if you actually go and you rent a hotel room and you outstay what you pay for, that's a different situation than somebody who has been living there for months and months, has been paying rent, might have an actual lease agreement, the landlord-tenant situation. So it's difficult to say with any certainty exactly what you're considered under the law, whether you are considered a trespasser, whether you are considered a tenant. That's something that would need to be evaluated by a legal professional, like say someone at legal services, and then ultimately would have to potentially be evaluated by the court system and a judge. If you are in a situation such as that, rooming house, boarding house, hotel, motel, and the landlord tries to change your locks or lock you out or terminate utility services, the first and best option would be to call 911, talk to the police, see if they are able and willing to intervene in any way to try to help you with that situation. And then to also call, if you're in our service territory, MidPenn Legal Services immediately. And if you're not in our service area, there is a legal aid office for every county in Pennsylvania. It just might be a different organization other than MidPenn Legal Services. Again, if you were to go to the internet, look up Google, look up legal aid in your county, you should be able to find contact information for your particular legal aid office. So the last thing we want to touch on for updates is for subsidized tenants and renters. And what we want to talk about is the Coronavirus Aid, Relief, and Economic Security Act, which we love acronyms, the CARES Act, that was enacted by Congress and signed off by the President on March 27th, which includes important and immediate protection for renters and tenants that are living in certain types of federally subsidized housing. So now, what does this mean? So the provisions that are most important to you folks, beginning on March 27th, there is a 120-day moratorium on evictions for non-payment of rent for tenants living in certain types of federally subsidized housing. We'll unpack that a bit in the next few slides. Furthermore, during the moratorium, the landlord cannot charge late fees or any other fees or charges related to non-payment of rent until on or after July 25th, that 120-day moratorium deadline. Now, so here are the different scenarios that you're likely to encounter if you're a tenant living in subsidized housing. So if you're a tenant who currently owes money for rent or fees or other charges to a landlord, but the landlord has yet to serve you with an eviction notice, then the landlord cannot give you the eviction notice at this time. The landlord cannot give you that notice until on or after July 25th. Also, if and when your landlord serves you with an eviction notice for non-payment of rent, which again, on or after July 25th, that notice is required to give you 30 days to cure the default or set up a payment agreement or vacate the property before they can file a complaint at the local MDJ's office or in the Court of Common Pleas. So it's really July 25th plus 30 days. So you're looking at towards the end of August would be the soonest that a landlord under these circumstances would be able to file a complaint against you and begin a legal action against you if you are a tenant in covered housing under the CARES Act, which again we'll touch on in a second. Now, if the landlord gave you an eviction notice for merely non-payment of rent before March 27th, then they cannot file a complaint during the moratorium. So this is one area where it differs from the moratorium at the state level under the state Supreme Court order and the county orders. The courts are still open for business in those cases. Under the CARES Act moratorium for subsidized renters, the moratorium protects against new filings, again, until on or after July 25th. So if you'd already been served with a notice before the moratorium went into effect on March 27th, your landlord can't file now, your landlord can't file next month or in June or July until after, on or after July 25th. Now, the federal eviction moratorium under the CARES Act does not affect the following situations. It does not affect cases that were filed before the moratorium took effect. So for instance, if you're a subsidized renter and your landlord filed a case against you at the MDJ's office before the moratorium took effect, although the hearing will not be scheduled right away because of the court closure, the hearing will still proceed as the court schedules it, despite this federal moratorium. It does not cover cases that were already filed. So in that situation, we do get a blend or a mixture of the two moratoriums that come into play. You're not covered by the moratorium under the CARES Act, but you will at least get some protections because of the moratorium and the foreclosure put in place by the Pennsylvania Supreme Court and the county courts. In those cases, as soon as the court's open for business, if there's already been a case filed, even if you're a subsidized renter, you're going to have a hearing as soon as the court opens back up, and this moratorium is not going to help you in that case. It also does not affect cases involving what are called non-covered tenancies, and we'll talk more about that shortly, but just understand that generally speaking, the only non-covered tenancies out there are going to be tenancies involving private landlords who own properties outright and who do not have a mortgage, or if they have a mortgage, they're one of the relatively small group of folks who do not have federally backed mortgage, which again, come back to in a second. It also does not affect cases involving eviction based on a serious or material breach of the lease that is other than non-payment of rent, other fees, or charges. So again, the moratorium is meant to be focused on making sure that people are not evicted for not paying their rent during this time. The moratorium is not meant to protect everybody from being evicted. It's only for those folks where non-payment of rent is the only issue. If there are other issues such as illegal activity in the unit or unauthorized occupants, the landlords in these scenarios are going to be able to proceed as if the moratorium does not matter to them, because again, the moratorium is only for non-payment of rent cases. One thing to be leery of is if you have a situation where there is non-payment of rent and the landlord has filed for some other reason, if you truly do believe that that some other reason is just an ulterior motive for your landlord to evict you for the non-payment of rent, if you think that's really the reason why they're trying to get rid of you, there may be some room in there for arguments to be made, even if the landlord is technically filing it as some other reason. So keep that in mind. But for the most part, if it's pretty clear cut, if it's not about rent, if it's just about something else, the landlord's going to be able to proceed as if the moratorium is not even in place. So now, the question that needs to be answered then in order for the moratorium to come into play for you is, does your tenancy qualify for the protections under the CARES Act? And I'm here to say that, again, I'm speaking very generally. I think almost across the board to the majority of folks who are subsidized renters or even private renters, for the majority of folks, the CARES Act is going to cover you. There are, of course, scenarios where you're not going to be covered, but the vast majority of renters, whether they are renting from a subsidized housing provider or even if they're renting from a private landlord, the vast majority of folks may very well be covered under the CARES Act. Almost all of the subsidized housing providers are going to be covered. And then again, the vast majority of even private landlords may be covered as well. So now, here's the kind of, this is the cases and these are the programs that are covered. This is not an exhaustive list. I've only put on here what I think are kind of the most frequent programs that we encounter with our clients. And I think this is going to catch the majority of you. But if you don't see your living situation on this list, feel free to check with your local legal aid provider, and they can work through the actual and more exhaustive list with you and let you know whether or not you're protected. So, CARES Act covers public housing subsidized by Department of Housing and Urban Development. So you might have heard the term HUD, right? HUD housing. It also covers the Section 8 Housing Choice Voucher Program. So if you have a voucher from the Housing Authority and you're renting from a private landlord, you're covered. If you live in Section 8 project-based housing, which is a situation where maybe you don't have a voucher, but you're renting from an apartment complex who has a Section 8 subsidy directly with HUD, so your rent is still subsidized while you're living there, that is covered under the CARES Act. Section 202 housing for the elderly under HUD, covered. Section 811, housing for people with disabilities under HUD, covered. The Low Income Housing Tax Credit Program, LIHTC, which is the now the largest program for subsidized housing across the nation, LIHTC, is covered. Section 515 rural rental housing is covered. And then properties, even if owned by private landlords, that have federally backed mortgages in play are also covered. So now, for programs with project-based subsidies, here's what you want to try. So these, again, subsidies that are attached to the building or the unit as opposed to being attached to the tenant. You want to try to look to the following sources to be able to determine whether or not your tenancy is covered under the CARES Act. You're going to look at your lease agreement, especially if you live in a property where there is a lease addendum attached to your lease. So that's in PA, that comes into play for LIHTC properties. You're going to look at your annual recertification documents to see if it says anything about HUD programs being in play. You can search the National Housing Preservation Database at the link that's provided there. You can go on and input your information and search that, use that tool to search and see if your tenancy is covered. You can look at the Pennsylvania Housing Finance Agency, the PHFA's rental housing inventory of affordable housing. And there's the link to check that out and see if you are living in a property that is covered by the CARES Act. Now, if you have a tenant-based subsidy, which again is the subsidy that follows the tenant as opposed to the building, you can look at the following. Again, look at your lease agreement, check and see if there are any lease addendums, look at your annual recertification documents, contact the housing authority. If you have a voucher in play, you can contact the housing authority and try to seek clarification from them. Now, where it'll be trickier for most folks, maybe everybody, is if we're talking about the private landlords that have federally backed mortgages. It's going to be difficult for you as a tenant to be able to identify whether or not your private tenancy is covered by the CARES Act. One thing that you can do, depending on your communication with your landlord, is you can ask your landlord, simply ask your landlord if they have a federally backed mortgage. If they don't know, see if they can check. Best to do this in writing if possible. If you can email, I know a lot of folks text, which is not the best, but at least something in writing where you're asking your landlord if his property has a federally backed mortgage in play. And if the answer is yes, then you're going to be covered under the CARES Act moratorium, all the same as the subsidized housing renters. Now, you can also call Fannie Mae or Freddie Mac. All the information is there. Now, the problem that you're going to run into if you're a tenant is that you would need to know your landlord's either employer identification number or tax identification number in order to be able to utilize that lookups tool as a tenant as opposed to the landlord. So the landlord should have all the information that he or she needs to be able to look it up, but you as a tenant will not be able to just readily search that information unless you have that information from your landlord. What I can say is that there is a movement afoot to try to require landlords who are filing eviction actions and new cases to disclose to the court, whether it be the MDJ or the Court of Common Pleas, whether or not they are covered under the CARES Act. There is nothing definitive on that yet, but that certainly is something that the legal aid community has been keeping a keen eye to and that we're working towards. And again, we'll provide updates as soon as we have any to that. And now, what should you be doing as a tenant during these moratoriums? What are the best practices? This is what we're going to wrap up with here, okay? So what you should be doing, if you're able to do so, is you should continue to keep paying your rent to your landlord as you normally would, because at least as of right now, there's been no indication from the government, from the Supreme Court, from the county courts, no indication that your rent is ultimately not going to be owed. We've not seen anything about there being a forgiveness aspect to any of these moratoriums. Now, there certainly has been money that has been approved by the government to help folks with rental assistance on the back end, and there's a lot of moving and shaking going on right now to try to figure out how to get that money into the hands of folks. And again, try to keep you updated on that if we can. But what you should be doing, if you're able to do it, is operate under the premise that even though these moratoriums are in place, even though your landlord can't file or might not be able to physically evict you, that it's essentially just kicking the can down the road. There is a possibility that your landlord may be evicting you down the road for the non-payment if you do not pay. Obviously, you know that folks have fallen on hard times during this time, so we understand that this might not be doable. If it is doable, that should be your practice. Now, and again, we talked about just there, the moratorium only means that you can't be evicted. Doesn't mean that they're not going to be able to file once it ends. And again, there are some things being done to try to make sure that we don't have an opening of the floodgates effect once the moratorium ends, but we don't have on that end to be able to report. So if possible, I think the best practice is to contact your landlord if you haven't already done so, discuss the situation with him or her, see whether there's any type of agreement that you might be able to reach. Some landlords have been forgiving rent. I know that's probably a bit of an anomaly, and you can't expect that, but you may be able to at least work out repayment agreements or plans. I would like to think that most landlords understand what the situation is, especially that most of these folks, they know what your income source is, so they'll know if you have lost your job or if you're continuing to work. And so my guess is if you have an open line of communication and a good discussion with your landlord about it, you may very well be able to try to work something out to avoid eviction whenever the moratorium ends. Primary funding for legal services is listed here: LSC, the Pennsylvania Legal Aid Network, United Way, and the Pennsylvania Interest on Lawyers Trust Accounts Board, IOLTA. We thank all those folks for making these things possible. And again, if you folks have any questions, what you want to do is you want to reach out to your local legal aid provider and you want to contact them for any assistance that you might require during this time. And again, folks, stay safe, stay healthy, and please keep checking back, because we will try to keep you folks updated as best as we can. Although things are happening almost on a daily basis, we'll try to provide any information that we can as it becomes available. Thanks again. Take care.